Okay, welcome to this edition of 10-Minute Takes from Brodies. My name is Joyce Cullen and I'm a litigation partner in our Business Disputes division, along with my colleagues Ross, Mitchell and Jane Rattray, who are both associates with a special interest in alternative dispute resolution. We're going to talk this morning about remote mediation in arbitration and what that means on a practical level for parties trying to resolve disputes during COVID-19 and beyond. So Jane, can you tell us a bit about how a remote mediation works?
Sure, Joyce. So what happens is that the mediator sets up a meeting using a video conferencing platform such as Microsoft Teams or Zoom. Usually it is preferred to have a video connection for all of the participants, but it will also work to mix and match video and teleconferencing. The mediator will send an email to each party with a link to the meeting, and then all the party has to do to join the meeting is to click on the link and follow the instructions.
Well, that sounds fairly straightforward, even for those of us with relatively little technical expertise. Tell me, Jane, is there a difference between preparing for a remote mediation and one where everyone is in the same location?
Overall, the preparation's pretty similar, but of course there are additional IT preparation steps for the remote mediation. So before the mediation, all the parties will have to download the software for the video conferencing platform. The good news, though, is that both Zoom and Microsoft Teams are free, so parties won't need to purchase the software. The parties should also test their connection to the video conferencing platform before the mediation. Usually what will happen is that in advance of the mediation, the mediator will arrange a test meeting with each party to make sure that the technology is working and also to answer any questions that a participant might have about the mediation.
Great. So assuming the technology all works, can you tell us a bit more about what would actually happen on the day of a remote mediation?
So each party will have received an email from the mediator with the meeting link. At the appointed time, parties click on the link, which brings them into the waiting room, and they will see their case details on the screen. Nothing will then happen until the mediator starts the mediation. Once mediation is started, the mediator will invite parties into their pre-assigned breakout rooms, and the mediator will explain to each breakout room how the process is going to work. At the private opening sessions in the breakout rooms, the mediators will discuss with the parties whether a joint session is wanted by the parties, and if it is, then the mediator will bring the parties from the breakout rooms into a virtual joint session, and then the mediation will proceed really as it would in person.
Great. So all being well, and if we manage to reach agreement at the mediation, how do the parties actually document what's been agreed with everyone in different places?
Well, drafts of the settlement agreement would usually be circulated by email anyway, and then revised by each party and finalised in the same way. If the parties both have printers and can sign the documents and then scan or take a photograph of the final version, then they can exchange copies of the signed agreement by email on the same day. Ideally, the settlement agreement would be signed and sent to all parties on the same day. But if that's not going to be possible, then an agreement could be reached on the wording of the settlement agreement by email, and then arrangements put in place for signing and sending copies to all of the parties afterwards. It's also worth bearing in mind that the agreement could be executed using electronic signatures, but as you will know, Joyce, that's another topic in itself, so I'm not going to go into that in any detail today.
Yes, I think that's definitely one for another day. Jane, in your experience, does remote mediation work as well as face-to-face mediation?
I think the short answer to that is yes. I was recently involved in a remote mediation, which was part of a Bristol High Court case involving a dispute over sale of a high-value villa in Florida. And in that case, it was agreed between the parties for the mediation to be held remotely, with the claimants, their barrister and lawyer, and the mediator all being down in Bristol, and then my clients and myself being in Aberdeen. And that saved our clients significant costs in travelling to Bristol, paying for our costs and time in travelling to Bristol, as well as the room cost for the mediation. In the end, the mediation lasted about 10 hours, but we did successfully manage to reach a conclusion, and we signed the consent order to dispose of the court action on the same day. Might be that some of our listeners are a bit sceptical about remote mediations, but my experience certainly is that it is a good alternative to face-to-face mediation. It doesn't diminish the chances of reaching a resolution, so certainly I would encourage parties to consider remote mediation as an effective alternative method of resolving disputes.
Well, thanks, Jane. That's all very encouraging. Turning, Ross, now to remote arbitration, given the current restrictions on us all, what options are available, particularly for commercial disputes?
Yes, Joyce. Well, like a lot of commercial litigation practitioners, I've got cases at the moment that we're either in the middle of proceedings or in some cases just about to commence arbitration prior to the lockdown. Now, we all know that obviously businesses want to still resolve disputes as quickly as they possibly can. And so what we're now looking at doing is ways to conduct an arbitration remotely. And actually, the existing procedures that are set out in some of the most commonly used arbitration rules, such as the ICC rules, are actually already pretty flexible, and so can respond well to unexpected changes in circumstances like the ones we find ourselves in. So, for example, there already is the option to have arbitration on the basis of documents and written submissions only, and that's a concept that practitioners will already be familiar with. So, without witnesses giving evidence and without any element of oral presentation and being in person at all. Now, they weren't particularly well known or discussed before now, but there are existing rules on conducting arbitrations remotely, which are known as the Sole Protocol on remote arbitration. And despite the fact that clearly this is something that everyone is particularly interested in now, the protocol was actually devised in November 2018. And that was because it was already in recognition of the fact that international arbitration was something that was becoming increasingly common in a more globalized marketplace, whereas at the same time, the underlying video technology is getting better, more powerful, and more sophisticated, I think we're all coming to learn about. So therefore, as with other changes that we're seeing generally at the moment, such as an increase in working from home that COVID-19 has already accelerated, I think the same can be said about remote arbitration. It's something that was beginning to happen already, and this is just a change that is becoming accelerated.
That's interesting. Is it possible, if one party wants to go ahead with the arbitration, that they can insist on remote arbitration rather than waiting for a hearing in person?
Yeah, so it really depends on which arbitration rules you're using. And in theory, all arbitration bodies are free to adopt. And under ICC rules, for example, it would be perfectly competent if one party was to request a remote arbitration that the arbitrator was to insist on it being conducted in that way. There is a real incentive on arbitration organisations at the moment to be seen to be flexible and respond to the current situation. We've seen quite a quick response from the International Court of Arbitration, as I've already discussed, part of the ICC, to facilitate and encourage remote arbitration. So, for example, on the 9th of April this year, it published a guidance note which made it clear that if remote hearings can be adequately implemented, then ultimately there's going to be less disruption to businesses, which will need disputes resolved quickly in order to move on. So they've already pointed out that the arbitration tribunal can take measures, including resolving disputes on the basis of either documents only with no evidential hearing, or alternatively using audio or video conferencing facilities where possible. So, yes, the answer is that if one party was to request it and the arbitrator was to insist upon it, that's something that all parties will just have to work with.
Yeah. So, you talked a bit about using just documents and perhaps just having submissions of lawyers, but it sounds from what you say, it's still possible for witnesses to give evidence in remote arbitrations if that's needed?
Yeah, certainly. I suppose the background is that we are seeing Scottish courts, for example, already beginning to take evidence remotely via video link as standard in cases now. Of course, it is something that courts have been able to do for several years now in the context of examining witnesses in other countries via video link. The difference is now, though, is that witnesses are going to be in their homes rather than in a courtroom. So to go back to the SOLE protocol that I mentioned, it sets out a couple of principles that will likely be applied to witnesses giving evidence in all remote arbitrations. So, for example, having a very clear desk, being able to see a reasonable portion of the witness's face and upper body to ensure that there's no one else in the room. And what, for example, will make it a lot easier is if the witness can have two screens, one if they're being referred to documents and one to actually see and still have that level of interaction with the person examining them.
Yeah, so it could be made to work, obviously. Are there any other major differences between a remote and a face-to-face arbitration?
Yeah, I mean, the big one is the big other element, other than witnesses, is obviously documents. So documents will need to be lodged electronically. The IC, for example, are insisting that all documents now be lodged electronically. And there will need to be a bit more preparation on making sure the technology works in the same way that Jane was mentioning in relation to remote mediation. So parties will need to make sure that they can do practice sessions to see that technology works and that there isn't going to be a problem on the day.
Yeah, and it sounds as though you see some advantages to arbitrations being run remotely. Do you think they'll continue even after the COVID restrictions have been lifted?
I think they will, for two main reasons. One is cost and two is time. I mean, the cost of, for example, traveling, preparing meeting rooms, preparing paper bundles of documents, those are not insubstantial costs in the context of quite a big arbitration. And the other issue is that it's probably likely that the arbitration will take place on a shorter timescale. There are just going to be fewer issues with scheduling convenient dates for parties to travel and find meeting rooms. So, my view is that in theory, arbitration is a faster and cheaper way of resolving disputes than a court process in many cases, and conducting them remotely only aids that benefit.
Thanks, Ross. That all sounds very positive. And thanks to our listeners for tuning into our 10-minute take on remote mediation and arbitration. Our 10 minutes are used up, but if you have a question that you wish we'd answered, please feel free to contact myself or Jane or Ross, and you'll find our contact details on the Brodies website, www.brodies.com.